Today we are here to discuss H.R. 3309, the Innovation Act. The enactment of this bill is something I consider central to U.S. competitiveness, job creation, and our nation's future economic security. This bill takes meaningful steps to address the abusive practices that have damaged our patent system and resulted in significant economic harm to our nation. During the last Congress, we passed the America Invents Act. Many view the AIA as the most comprehensive overhaul to our patent system since the 1836 Patent Act. However, the AIA was, in many respects, a prospective bill. The problems that the Innovation Act will solve are more immediate and go to the heart of current abusive patent litigation practices. This bill builds on our efforts over the past decade. It can be said that this bill is the product of years of work. We have worked with members of both parties in both the Senate and the House, with stakeholders from all areas of our economy, and with the administration and the courts. To ensure an open, deliberative, and thoughtful process, we held hearings and issued 2 public discussion drafts in May and September of this year, which led to the formal introduction of the Innovation Act last week. Abusive patent litigation is a drag on our economy. Everyone from independent inventors to startups to mid- and large-sized businesses face this constant threat. The tens of billions of dollars spent on settlements and litigation expenses associated with abusive patent suits represent truly wasted capital that could have been used to create new jobs, fund research and development, and create new innovations and technologies that promote the progress of science and useful arts. Within the past couple of years, we have seen an exponential increase in the use of weak or poorly granted patents to send out purposely evasive blanket demand letters or file numerous patent infringement lawsuits against American businesses with the hopes of securing a quick payday. Many of these abusive practices are focused not just on larger companies, but against small and medium-sized businesses as well. These suits target a settlement just under what it would cost for litigation, knowing that these businesses will want to avoid costly litigation and probably pay up. Such abusive patent suits claim ownership over basic ideas, such as sending a photocopy to email, aggregating news articles, offering free Wi-Fi in your shop, or using a shopping cart on your website. Something is terribly wrong here. The patent system was never intended to be a playground for litigation extortion or frivolous claims. One egregious example is of a company that has been suing small app developers and end users over a vaguely worded patent that claims that any app that allows for in-app purchases violates their patent. This early 90s patent apparently discusses a method for providing remote customer feedback using a fax machine. Though their patent may not be novel or non-obvious, they made their first obvious error just last month when they sent Martha Stewart a demand letter asking for $5,000 for each of her company's 4 apps. Instead of paying up, Ms. Stewart filed a declaratory judgment action in federal court in Wisconsin. Fortunately, Ms. Stewart chose to fight. Unfortunately, many small businesses simply do not have the resources to do so and must capitulate to this type of patent extortion. The Innovation Act contains needed reforms to address the issues that businesses of all sizes and industries face from patent troll-type behavior, while keeping in mind several key principles, including targeting abusive behavior rather than specific entities, preserving valid patent enforcement tools, preserving patent property rights, promoting invention by independents and small businesses, and strengthening the overall patent system. Congress, the federal courts, and the PTO must take the necessary steps to ensure that the patent system lives up to its constitutional underpinnings. And let me be clear about Congress's constitutional authority in this area. The Constitution grants Congress the power to create the federal courts, and the Supreme Court has long recognized that the prescription of court procedures falls within the legislative function. To that end, the Innovation Act includes heightened pleading standards and transparency provisions, requiring parties to do a bit of due diligence up front before filing an infringement suit is just plain common sense. It not only reduces litigation expenses, but saves the courts time and resources. Greater transparency and information makes our patent system stronger. The Innovation Act also provides for more clarity surrounding initial discovery, case management, joinder, and the common law doctrine of customer stays. The bill's provisions are designed to work hand in hand with the procedures and practices of the Judicial Conference, including the Rules Enabling Act, and the courts, providing them with clear policy guidance while ensuring that we are not predetermining outcomes and that the final rules and the legislation's implementation in the courts will be both deliberative and effective. We can take steps toward eliminating the abuses of our patent system, discouraging frivolous patent litigation, and keeping U.S. patent laws up to date. Doing so will help fuel the engine of American innovation and creativity, creating new jobs and growing our economy. I look forward to hearing from all of our witnesses on the Innovation Act and the issue of abusive patent litigation.